very confused. I talked to this court.
Saying, ma'am, I don't have a record of that.
I sent it to the court.
Even
this is on them. I mean, I didn't have to lose my job. And
there's this Tamara Coppins.
Good afternoon, Your Honor. Rachel Dornbush, Palace Law, on behalf of the plaintiff.
Hello, your name?
Tamara Coppins.
Tamara Coppins. I messed up the whole name, didn't I?
That's okay.
All right. What is plaintiff's claim today in this case?
Your Honor, let me
Oh, this is
verify.
actually her motion to set aside.
That's correct.
All right. And ma'am, what's your basis for setting aside the judgment?
I took a fall on their property and busted my kneecap in half. That was February 2nd, and I lost my job, a great job. I had just been approved. I worked for the Veterans Affairs. And I'm not quite sure I know what set aside means. I have tried to make payment arrangements with them. In fact, I even tried to make some payments, but I'm blocked to make them. And
let me stop you there.
Sure.
This is a motion to set aside the judgment which you filed.
Okay.
And in order to, I'm not even sure how it got set for a hearing because escrow was not paid or a bond wasn't paid on this. But that notwithstanding, there are two things that you have to show me. You have to show me that you have a meritorious defense to their claim for Rant. And then the other thing that you have to show me is you have to have some good cause for your failure to appear back on May 23rd of 2025.
Yes, I can.
Okay, so why?
I went to the courthouse and it was closed in Saline. I'm on the summons, which I've never had before. It said appear to the court address above, and it said Zoom, but that box wasn't checked. I honestly thought that I would go to the courthouse, which I did do, and the judge would be on the screen. That's what I thought. But when I got there, it was shut down.
Yes.
And so then I panicked and I called, and the Northfield Estates told me, nope, you're evicted. And I'm like, what? And then I wrote a letter, and then the lady I was working with said, you got to fill this out. I filled that out. And I had no problem paying some money to an escrow. I didn't know about that. But basically, I've tried to make payment arrangements, but I feel strongly that they should work with me because this is on them. I mean, I didn't have to lose my job and fall. And so they should work with me.
Ma'am, so let's assume I take that as a good cause. You're not disputing that you owe the amount.
I am disputing it in the sense that they should negotiate with me because I lost my job because of their mistake.
In what sense?
Negotiate that I don't have to pay the rent or pay some of it until I get back to work. And then the whole thing, because I literally fell on their property and lost everything.
I understand that, ma'am, but I don't know anything about that as to whether or not it's their fault. I
understand what you're saying, but I've given them all my medical records. They know that's why I was surprised when I got the summons. Actually, my mom got it, and I'm glad I saw it because she doesn't have a great memory.
Ma'am, I don't know whether it's because of anything that the landlord did that caused the fall. And that would not be before me.
Okay.
So the real question is how are you going to get this judgment paid?
I've offered them
because there's probably more owing now.
Oh, I'm sure that there is.
And Your Honor, the total that's due at present, Your Honor, is $2,902.32. And Your Honor, if I could just state my position with respect to the motion itself.
Yes.
I don't believe that Ms. Coppins has good cause for her failure to appear. She indicated that she went to the courthouse in Saline, which understand the courthouse is closed for renovations. But there's no indication that Ms. Copens then called the court to say, hey, I'm at the courthouse, it's closed, what do I do? Instead, she waited until later that afternoon to email me and say, hey, can we reschedule this? I had responded and said, unfortunately, no, judgment has already entered, so the court case is not going to be rescheduled. And so I don't believe that she's established good cause for her failure to appear. That's number one. Number two, I don't believe that Ms. Copens has established a meritorious defense to the underlying action. Your Honor, whether or not there was an incident on the property, and whether or not Ms. Copens can prove that my client was at fault for said incident, I am not conceding, Your Honor, in any way, shape, or form that they are. I would dispute any claims that they are. However, that is separate and distinct from any obligation that Ms. Copens has to pay rent, which she has not done. And so for those reasons, Your Honor, I would have to request that the court deny her motion and allow the judgment to stand in full force and effect. And at this point, we are well beyond the statutory 10 days that was entered on the original judgment, and would request permission for plaintiff to submit an order of eviction in this matter.
I would like to respond if possible.
Go ahead.
I'm not an attorney. I lost my cell phone service because I have no money. And I have to go hook up to a McDonald's or something, and I'm using these silly text apps. I got in touch with, I didn't know who to call because the place was closed. And then when I would hook up, I figured it out and I made my calls to the court. I don't know if I emailed them first. And I have had no problem. And I've repeatedly said, do we have to go to court? Can I pay this amount and catch up every month? So it is as if they want my dad's house. My dad was a vet, and it's like they just want it. So I don't even know what meritorious means. I don't think there's any doubt in Northfield Estates, but it's not for this court possibly, or it's clearly not, but I don't think they have any doubt of where I fell and why I fell. But I don't even care. I just busted my knee, never been in sports, never had that pain except for babies. And I lost a job at the NFPA.
Okay.
So why can I not make a payment schedule, like $1,000?
That's going to be something that has to be negotiated between the parties.
That's what I tried to do.
Okay. But if they don't agree to it, that means that you guys haven't come to an agreement on it.
Right, but they are now saying they want to evict me and my 83-year-old mom when the house has been in my family for 15, 20 years, and it's been paid every month because I didn't prove that there was a good cause. I didn't go to court.
Ma'am,
I'm
asking
confused.
the court to do something the court can't do.
Which is what?
I can't force them to enter into a payment plan.
Okay.
All right. I am here right now on your motion and have to rule legally on your motion. And I told you at the very beginning, 2 things that you needed to show me: your good cause for your failure to appear, as well as a meritorious defense of the claim.
And both,
Frankly,
I've done none of those.
You have to show me both of those, and neither of those have you shown me.
I did.
We had gotten a call, and it sometimes does happen, and I'm not going to dispute that somebody goes to the wrong courthouse. We get a call, we get something.
You did.
That day.
You did.
Saying, ma'am, I don't have a record of that.
I sent it to the court, and you emailed me back.
Ma'am, don't overtalk me.
Sorry.
I'll let you go on. I'll let you tell me anything, but you're going to have to stop over talking.
Okay.
Even if you did, and even if I were to find that that's a reason for not appearing, I don't have a meritorious defense of the rent claim. I have to have both.
I don't have a lawyer. I wasn't told that, nor do I even know exactly what that means. So bottom line is they want $3,000, or what? How much does she want?
It would be $29,0218, but if you pay $22,3479, that may stop the eviction.
I'm very confused. I talked to this court. I spoke to this court. They emailed me back and said, Judge Simpson has set this aside. You're going to go the 13th. So you're telling me to show you
I-
something
Ma'am,
that
told you that.
I have my phone, I have your emails, I have it from your courthouse. Not maybe
Your
not
Honor,
you directly.
I
Yes.
can,
She's been copied.
I've seen the email chain and there may be some confusion. The 14A4 civil clerk did send an email on June 2nd stating Judge Simpson has granted your motion to set aside default. The motion hearing is set or scheduled for 6/13/25 at 1 p.m. This will take place in person at the 14A1 District Court and provided the address. Have a great day. Ms. Copens forwarded that email to my firm on June 2nd. I then reached out to the 14A4 clerk and I said, the tenant forwarded our office the below correspondence. I asked for clarification as to whether or not the motion had been granted or if the court had simply granted a hearing on the motion. The civil clerk indicated judge has reviewed the motion and set it for a hearing on 6/13/25 at 1 p.m. And I said, so the motion is granted, is not granted, just set for a hearing. If so, that may need to be clarified with the tenant because I believe that Ms. Copens was under the belief that the judgment had been set aside, not that a motion had been granted or a motion hearing had been granted. I did correspond with Ms. Copens after that and explained to her that no, per my communications with the civil clerk, a motion hearing had been granted only, not that the judgment had been set aside, and that the hearing that was scheduled for today would be before your honor to determine if the judgment should be set aside or if the judgment would stand. Ms. Copens responded something along the lines of, I don't understand, I don't know the legalese. I'm going to take it to mean the judgment was set aside.
Ms. Dornbush, were you reading, did they indicate initially that the judgment had been set aside?
The email to Ms. Copens does say the judge has granted your motion and set a motion hearing. So it's a little ambiguous, Your Honor. The document that I believe was provided to Ms. Copens, and I'm looking for the notice to appear, it doesn't indicate hearing for non-payment of rent, it indicates motion hearing. And I'm looking for
Yes.
the attachment.
I'm looking at it now, actually. I'm looking at our notice that would have gone out. All right. All right. So you're having the hearing at this point, ma'am. I have not ruled on it at this very moment. However, I'm telling you, I need two things. And the first thing being that there has to be a meritorious defense. Second thing being, and as I'll just tell you, neither one has been shown to me. So the motion to set aside the default is denied, the judgment will stand and a writ may
So
issue.
you're saying that they can evict me?
Ma'am, what I'm saying is,
I honestly don't understand.
okay, then I'll tell you this. The judgment that was entered on May 23rd will stand. And in that judgment, if you read the judgment, you have a certain time in which to pay those funds. As I indicated, that amount was $2,234.79.
Okay,
If that is not paid, then the landlord can seek their remedy, which would be an order of eviction, indicating that nothing has been paid on this, and then have you removed from the premises. Yes.
okay, I have one more question. You were not going retrospective back that I had to pay it by the 23rd of that month. I can pay it today. Is that correct?
Do you have it today?
I can't, I will get it. I've got family and friends. I just wasn't gonna give
If you
1,000.
get it paid, they would need to, the way this court has ruled, they would need to accept it, so.
Is there
If
an
it gets-
appeal? Because
Pardon?
is there a way to appeal? And I'm saying that only because I was sent something.
Ma'am,
that
I
we're having a-
cannot, ma'am, I cannot give you legal advice. If you want to get legal advice on your rights.
I would like
appeal,
to do that.
Then you can go and do that, but my order that your motion is denied stands. Motion denied. Thank you.
Well, I guess, you're welcome. All right,
Court calls the case of River Ridge versus Kaylee Hamill Little.
Far too often with people in other parties such as this, and you just can't seem to work it out. Don't resort to taking the law in your own hands.
We'll hear the litigants' reaction.